Well,
And how about Penelope?
Well, Penelope, she's only 2, so I think she'd be happy with just about it.
Oh, that's great.
Well, that's great.
Yeah. Oh, that's wonderful that you have a 2-year-old.
Well,
have a Merry Christmas. Have a wonderful Christmas.
and by the way, you guys have to be in bed by 9 o'clock, and asleep between 9 and 12, or he doesn't show up.
This isn't to you, Jared. This is to the kids.
That's right.
Well, I hope you have a wonderful Christmas.
Well, yeah, I hope you guys have a wonderful Christmas as well. Merry Christmas, and let's go, Brandon.
Let's go, Brandon. I agree. Hey, by the way, where are you in Oregon? Where's your home? I think we lost him.
Yeah.
Who will rid me of this meddlesome post?
What do you want? Your death.
Today on Legalese, we are going to be discussing a case coming before the Supreme Court this coming week that may very well be the most disturbing case I have covered here on this channel. This is the case that was previously known as Missouri v. Biden, but which is now coming to the court as Murthy v. Missouri. And whatever you may have heard about this case in the news, I assure you, it gets much worse than you realize. Hey, greetings everybody, and welcome back once again to Legalese. As always, I'm your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me bid a special welcome to you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, if I can remind you guys real quick, if you want to find out more about the show, you can go check out our homepage over at legalesepodcast.com. And if you want to stay up to date whenever I put out any new content, because I also do not just videos on YouTube, but I do articles on Substack. There's an audio-only version on Spotify. I post to alternative platforms. And if you want to get updates from whenever I put out new content, no matter where or what it is, all you have to do is head on over to legaleseshow.com, sign up for our newsletter, and from there you will get notifications sent right to you. All right, well, today we really have a whole fucking hell of a lot to get to, so we are going to just jump right in. So as I mentioned off the top, today we're going to be covering a case, and actually, this is a case from my Supreme Court roundup, and we are talking about the case of Murthy v. Missouri. Now, if you are thinking to yourself, well, Bob, I don't remember you including this case in your October or November episodes that covered your full caseload for your Supreme Court roundup for this term, you're absolutely right. While I have been following this case personally since the district court ruling came out on July 4th of 2023, the fact is that this is indeed a difficult case to cover, both for its legal complexity and on a more personal note for what are really, to me, the fairly infuriating nature of the facts of this case. Now, this case has to do with a practice known as jawboning. Jawboning is a term that refers to when government takes action by doing something indirectly they are unable to take action on directly. And they achieve this through leaning on intermediaries to do for them the thing that they are not authorized to do themselves. And in this case, what we're talking about here is mass censorship that facially violates the First Amendment. And of course, a fundamental principle in constitutional law is that anything the government is not empowered to do directly, they are equally barred from doing indirectly. And this kind of state action seems to me especially egregious, as the very fact that they are engaging in jawboning tells you that they completely understand that the activity they are engaging in here is a usurpation of their power. But as I alluded to off the top, this case is one with an incredible amount of complexity. In fact, so much so that this case simply cannot be discussed without a much more thorough understanding than usual of the facts of the case and the procedural history in the lower court. And again, because this is such a uh, complex topic, today we're going to be doing the first of two videos necessary to prepare you guys for the upcoming oral arguments in this case before the Supreme Court. Today, we're going to be discussing the background and the facts of this case and its procedural history up to and including that preliminary injunction that was granted by the district court in July of last year. Now, the next video on this case will be covering the Fifth Circuit appeal as well as the merits of the case on which the Supreme Court would grant cert back in October 20th, 2023. And between these two videos, this will get you guys completely up to speed so that when the court hears oral arguments in this case is coming Monday, March 18th, you will understand everything you need to know to fully comprehend this case when it does come before the court. But understanding the basics of this case that we will be covering here today is also important for another reason, because to the extent that people do tend to learn about important Supreme Court cases such as this, they usually get their understanding from either the corporate media or from politically derived discussions of the case. And if I may be so bold, I would say that anyone whose understanding of this case comes from those sources just doesn't understand this case. Now, to the extent it has been discussed in the liberal media and by liberal politicians, it has been discussed with the very same sort of tone and context as Vox would describe it here in an article of theirs from September 29th of 2023. So they say, quote, Murthy would devastate a Democratic administration's ability to ask social media companies to voluntarily remove content, end quote. Now, the truth is that as we go through these correspondences in this case between the government and the social media, the extent to which the government is using both threats and coercion to get these social media companies to do their bidding is truly shocking. Now, on the other hand, what we have is a Republican media and a Republican political class which refuse to discuss this case except as being some kind of, as they will claim, completely new phenomenon of censorship that only began in January of 2021, conveniently as soon as the Biden administration took office. Now, of course, furthermore, the GOP has lately taken to claiming that they are the principal defenders of online free speech. Now, this is a claim which the falsehoods and rank hypocrisies thereof have already been covered by us here on the channel in my past net choice cases, which I'll link on the show notes page. But this aspect of it is also something that we will be exploring in much greater detail in my upcoming video on Murthy v. Missouri. So let's quickly, as quickly as possible, try to sum up the basic facts of the case here in the procedural history up to and including the district court's preliminary injunction that was issued on July 4th of 2023. So this case started with two cases filed by the attorneys general of the states of Missouri and Louisiana. Now, these were filed in conjunction with a nonprofit group that is known as the New Civil Liberties Alliance. And the suit that they would file back in May of 2022 was really filed on behalf of two different buckets of clients. Now, the first one was on behalf of citizens of those two states of Missouri and Louisiana because they are alleging that they had been damaged by the restrictions on the First Amendment's free flow of information that came about as a result of the allegations. But they would also go on to take this case on behalf of several individual plaintiffs, and these are specifically two doctors and one journalist from the Gateway Pundit. Now, as far as the defendants in the case, what we're talking about here is really sort of an alphabet list of administrative agencies in the federal government. And additionally, it includes particular people and offices, including President Joe Biden, numerous members of his cabinet, and perhaps most notably would be his Surgeon General Vivek Murthy, as well as high and mid-level staffers of these agencies, and this would include the CISA, which is the Cybersecurity and Infrastructure Security Agency, who are perhaps the most pervasive and malicious of all the named defendants. But this list also includes the Department of Justice, the FBI, the National Institute of Allergy and Infectious Diseases, the CDC, Homeland Security, and additionally, there are a few other named defendants who are not involved particularly in the preliminary injunction that we are going to be discussing here today, and these include the Federal Census Bureau and the FDA. So let's look at a procedural history for the preliminary injunction in this case that was filed on July 4th, 2023, and it is as follows. So an initial complaint would be filed on May 5th of 2022. A motion for preliminary injunction would be filed on June 14th of 2022. Now, a motion to dismiss would be filed on July 12th, and a number of amended complaints would be filed throughout late September of 2022. Now, additionally, the court would grant discovery on this case back in September, with depositions being taken from many notable individuals, including among them Dr. Anthony Fauci and the Biden press secretary, Kareem Jean-Pierre. Now, the court made extensive factual findings in this preliminary injunction, and the preliminary injunction is one I will link to on the show notes page for this episode, and this is one that you guys really have to go read for yourselves. Now, usually, such specific dates in the procedural history as are laid out here aren't all that important, but I highlight them in this case for a very simple reason, and that is because to have a federal court case go from a complaint to a decision of the court in just about a year and 2 months is lightning fast, like record-setting fast litigation. And personally, I believe that this underwrites the grave nature and serious implications of this case, which is nothing short of mass censorship against potentially millions of Americans in this country, all done through CD-backed channel threats and coercions to hide what should be a nationwide that is outrage. It should be a nationwide outrage. Now, what I mean is that for the last 6 years, 2 presidential administrations have flagrantly violated the First Amendment on an unprecedented scale. And while liberals want to pretend that there is just nothing to see here, folks.
Okay, people, move along. There's nothing to see here.
Okay, folks, show's over. Nothing to see here. Oh my God, a horrible plane crash. Hey, everybody, get a load of this flaming wreckage. Come on, crowd around. Crowd around, don't be shy, crowd around.
Republicans in kind are desperate to deny the fact that their golden boy and presumed nominee in the election coming up later this year is indeed every bit as guilty of this very same mass censorship. And what Republicans want to keep hidden is the fact that the only reason Trump isn't also a named defendant in this case is because they are suing these politicians in their official capacity, and as Trump isn't in office right now, he can't be a party to this case. Though the social media jawboning, and I want to make this very clear, goes back clearly at least as far as 2018 and was carried out not only by Donald Trump personally, but numerous high-level members of his past administration. Now, the allegations of the complaint in short here are that the Biden administration specifically pressured and coerced the major social media companies to censor the plaintiffs for the disfavored speech online. And the topics included the Hunter Biden laptop story, the efficacy of masks, of the COVID vaccine, of the lab leak theory, and issues surrounding questions of election integrity, and also a number of what I consider much more odd demands for removal of content. And this would include parody accounts that mock members of the first family. Now, the allegations by the state plaintiffs are that the extensive federal censorship outlined in the complaint restricts the free flow of information on these platforms, and that in turn hurts the residents of the states. And the attorneys general of these states are suing under what is known as parens patriae standing to sue the federal government. Now, parens patriae is Latin for parent of the country or homeland. And under parens patriae, a state or court has a paternal and protective role over its citizens or others subject to its jurisdiction. Now, likewise, there is the parens patriae doctrine, and the doctrine of parens patriae is a doctrine under which a state has a third party standing to bring a lawsuit on behalf of a citizen when the suit implicates a state's quasi-sovereign interest for the well-being of its citizens. Now, a further amended complaint asserts that an additional First Amendment speech violation based on viewpoint discrimination is present. So it's not just that censorship occurred, but that it occurred on the basis of a viewpoint discrimination, which essentially means the decision to target the plaintiffs and their posts for censorship were regulations based on the perceived conservative viewpoints or viewpoints that were contrary to the government's position on issues related to topics such as COVID or election integrity. And following completion of depositions and discovery, a third amended complaint would be filed in May of 2023, and the preliminary injunction would then be granted barely 2 months later, which again is an unbelievably fast pace for federal courts. And I would say this fact speaks to the grave importance being put on this issue by the courts, and rightfully so. Now, the injunction that was granted was sweeping in its scope, and it came out almost entirely in favor of the plaintiffs and their allegations in this case, with just a couple of exceptions that we will be getting to a little later. But the sweeping nature of the preliminary injunction was based on the court's careful analysis and determination that the plaintiffs were very likely to succeed on the merits of their case. Now, in this instance, there is no case being filed against by the social media companies themselves. This case is focused exclusively on government action. And the court also went to great lengths to detail specific examples of the government's actions going well beyond the government simply exercising its own right to engage in speech. The court found it was clear that the government's actions coerced social media companies using their police powers in seeking to take down specific disfavored viewpoints, as well as giving significant encouragement to the social media companies to censor a vast plane of protected speech. Now, they noted that starting in the first days of the Biden administration, and in fact specifically just 3 days into his new administration, we already began to see the start of what would become an increasingly aggressive form of rhetoric coming from the White House demanding social media companies, and specifically Facebook and Twitter, should remove certain posts and certain speakers. And when that didn't happen as quickly as the government felt it should, and I want to stress, it's not that it didn't happen as quickly as they thought it ought to. They demonstrated a pattern of escalating with their aggressive rhetoric. And for the record, I realize that these companies, Facebook and Twitter, are now technically called Meta and X, but both rebrandings were fucking stupid.
Let me introduce Mark Zuckerberg. Thanks for coming, Mr. Zuckerberg.
Thank you. It is a great honor to be here amongst all of you.
For those few who don't know, could you tell us who you are?
I am the founder and chairman of Facebook, but I also have a style that is completely unblockable.
Okay, we'll let him speak and then we'll open the floor to some questions if there's time. Thank you.
Thank you, right? Alright, everyone here wants to see my style. But first, what I'll need is a volunteer. Yes, you, sir.
Mr. Zuckerberg, Facebook has become a tool for some to disrupt our country and our community.
You say these things like they are my fault, and yet they are not.
Well, you did create a platform with a monetary incentive for people to spread misinformation.
Ha 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 ha! Now I see you're trying to use your style over mine. Now, you try to block me. Now you've learned that you cannot block me, yes? Yes, what is your question?
How are we supposed to keep our kids... What was Mark Zuckerberg's point?
I don't even understand what that was about.
Guess nobody realized Mark Zuckerberg was such a penis.
Now, while I really want to like Elon Musk, the fact is the guy is kind of a douchebag. And simply put, Mark Zuckerberg is a penis.
So, where are we headed? Perhaps we should get some food.
What? Excuse me, this is our car?
You call this a car? It wasn't even remotely able to block me. What is this car's style?
Get out of here, you penis!
Ha 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 ha! You say I am a penis, and yet I am not a penis.
And this is why, as far as I'm concerned here on Legalese, they will always be Facebook and Twitter. Now, the government commonly refers to these companies in these findings as, quote, our partners. For example, one correspondent says, and I quote, I thought you guys were our partners. Are you going to cooperate, or are we going to have to take this in a different direction, end quote. And this sort of sentiment is one that you can find repeated in virtually every communication from pretty much every government official when contacting pretty much every social media company. Now, you may, in fact, I would say probably fairly reasonably, be wondering, why does it matter whether a social media company has completely voluntarily chosen to engage in what they call a partnership with the government? And the issue here is that we can find concrete examples of the government using these arrangements to achieve censorship by other means. For example, in February of 2020, Facebook CEO Mark Zuckerberg would email Dr. Anthony Fauci offering him a partnership to promote accurate information about the Wuhan coronavirus. And that led to Facebook, actually at Dr. Fauci's, direction, censoring the lab leak theory for more than a year. As we now know from FOIA requests on January 31st of 2020, Dr. Fauci received an email with a report from an NIH scientist, Dr. Christian Andersen, who said the virus was potentially engineered in a lab. So that email reads, quote, on a phylogenetic tree, the virus looks totally normal, and the close clustering with bats suggests that bats serve as the reservoir. The unusual features of the virus make up a really small part of the genome, less than 0.1%, so one has to look really closely at all the sequences to see that some of the features potentially look engineered. And because of this, Facebook and the Facebook government partnership would cause Facebook to preemptively censor credible scientific information for more than a year. And all of this because Dr. Fauci was able to beat expert scientists with a credible theory based on empirical evidence to the punch. So the fact is, their voices were, they never even had a chance to be heard or their facts evaluated on this matter of public health, and that Fauci knew that this lab leak theory was supported by his agency's own evidence at the time he made that determination. And according to the opinion of the court in the preliminary injunction, as a regulated company, you would find at least some of this language to be beyond friendly suggestions and straying into specific discussions with threats. Now, this would include such things as responding to pushback from these companies if they weren't going to play ball. And I want to note here that while these companies uh, often were more than willing to act as government censors, there were also many cases where they would push back for one reason or another. And when this would happen, the government would take steps such as suggesting, well, perhaps Section 230 was too broad and we need to repeal it. Here, the government is clearly saying, you're right and we can't force you, but if you won't do what we tell you to do, the government will start revoking your legal protections until we can force you to do what we want you to do. They have also had no qualms about reminding these companies that they have plenty of other tools short of exercising force over the company actions that can be employed to make things much more difficult and unpleasant in the meantime.
Daunting to the intelligence
Let me tell
community.
you take on the intelligence community, they have 6 ways from Sunday at getting back at you. So even for a practical, supposedly hard-nosed businessman, he's being really dumb.
Now, another escalation tactic that they would employ here following pushback from these social media companies was to make threats about bringing antitrust suits against these companies if they didn't do the government's bidding. And the court would conclude that tacking these threats onto so-called requests for voluntary compliance is clearly itself a coercive act. And the fact is, in all of this, there's really a sort of mafioso protection racket shakedown vibe emanating from all of these communications.
Boy, this sure is a nice social media company you got here. Sure would be a shame if, something bad happened to it. So Elon, how about you play ball and censor the malinformation posted to Twitter about me?
Malinformation, isn't that just true information that draws a conclusion you don't like?
That's exactly what it is. And bring me a little girl to sniff. So do we have an understanding?
Whatever you say, Joe.
I love it when they look scared. Come say hi to Uncle Joe, darling.
And another term the government would use to obfuscate their tactics was to call their communications, quote, significant encouragement, end quote. And the court's finding would characterize significant encouragement as defendants using meetings and communications with social media companies to pressure those companies to take down, reduce, or suppress the free speech of American citizens. Likewise, they found that when a state has so involved itself in the private party's conduct, it cannot claim the conduct occurred as a result of private choice, even if the private party would have acted independently, and that is according to a precedent that was set in Peterson v. City of Greenville back in 1963. Now, I believe that we will be hearing a lot more about these aspects of it as the case evolves. That is the extent to which, even though sometimes these social media companies were indeed immediately willing to engage in some sort of censorship following a mere request, the extent to which the government's actions, or as it's sometimes referred to by the court, the proximate cause, had such an impact that they're inextricably intertwined in the outcome. And the court found that some defendants, and I want to stress not all, but some defendants did make explicit threats towards social media companies to coerce content moderation decisions. And some defendants used threats to curtail immunity. And one source of this pressure would come specifically from the White House defendants, even when these communications did not come with any overt threat or coercion. I think one should very much keep in mind here that what these companies were faced with was unrelenting pressure from the most powerful office in the world. So here is the scope of the injunction that was issued by the district court last July. The court granted the motion for a preliminary injunction and enjoined the government defendants who were before the court for purposes of the injunction, which again is not all defendants, but some of them were enjoined from meeting with social media companies for the purpose of censoring protected speech, from flagging content or posts and then forwarding the post to social media companies for removal, basically creating something of a censorship machine inside the government that were then to be transmitted to social media companies and telling them to execute on these decisions made by government. Now, additionally, they enjoined the government from encouraging or pressuring companies to change their guidelines or their terms of service with respect to content moderation. And there are many examples where the government would request specific posts or topics be taken down, to which the social media companies would say, and I'm paraphrasing here, they would say something like, hey, look, government, that's actually not a violation of our content guidelines. We can't do that just because there is something posted you may not like. Now, in response, the government would often say something to the effect of, and I want to stress again here, this is a paraphrasing, something to the effect of, well, we don't care about your guidelines. We've just moved the goalpost, so you better take it down. And I just want to say here that while people can certainly disagree with my interpretation of the facts of this case, and you're certainly welcome to disagree with my interpretation of the facts of the case. What I would say is that everything we're talking about here is very much backed up by solid evidence in the preliminary injunction. And if you're going to take issue with anything I say or disagree with anything I say, that is, of course, fine. But I would ask you to at least go and read the original source of the preliminary injunction itself, because while it's, certainly possible that my interpretation could be, and I don't think it is, but I'm just being fair here, it could be, biased or incomplete. However, what can't be faked is the actual factual findings of the court themselves upon which my interpretations are based. And I would encourage you all to understand those deeper issues. Now, as far as the government's attitude of, we don't care about your guidelines, we have moved the goalpost, take this shit down, this is a strategy that has been unfortunately very effective at modifying these companies' attitudes. And in this way, the court would find these companies were being forced to change their guidelines according to government whims, or to take actions they did not want to in contravention of their guidelines to avoid the government's further censorship or retaliatory action. And the government was additionally barred from requesting content reporters from the social media companies detailing the actions they had taken to remove, delete, or suppress content. So, in other words, the court found the government's demands for information often going beyond helpful suggestions to monitoring these companies for tactics that would effectively increase their compliance with demands. And they were also barred from notifying social media companies to BOLO, which is be on the lookout, for specific posts or types of posts. Now, on top of the things which are barred by the injunction, there are also some exceptions mentioned in that injunction that I believe will get much more interesting and be much more important as part of this upcoming Supreme Court appeal. So these specific exceptions to the injunction include communication for issues of criminal activity, for national security threats, which was the initial purpose and function of the CISA in the first place. Also, criminal efforts to suppress voting, matters of public safety, which to me seems like a ridiculous loophole because so much of the material being censored had to do with COVID, including vaccine safety and efficacy, as well as mask safety and efficacy. And while the court would identify the COVID censorship as problematic viewpoint discrimination, the government could very plausibly say that these were matters of public safety. And other exceptions included permissible government speech that promotes government policies on views or matters of public concern. So the government still, of course, as it should be, is free to express their own views on these matters. And it also exempts communications about cybersecurity attacks from removing or reducing content as well that is, as they say, not protected by the First Amendment. Now, these exceptions are as interesting as the injunction itself, seeing as how it's left up to thousands of individuals in the government and in social media companies to basically decide for themselves what is or is not protected First Amendment speech. And seeing as how even First Amendment lawyers have a wide difference of opinion over what is and is not protected First Amendment speech, I can't even begin to imagine how it will be with so many people who are not lawyers looking at this requirement and having to ask themselves, how do we comply with this particular provision? And with such sweeping language in the injunction about what the government is prevented from doing, along with the handful of exceptions which create loopholes that are so big you could drive a Mack truck through them, pretty much every First Amendment attorney and scholar who are commenting on this injunction have shared basically the same criticism that this injunction somehow manages to be both overly broad and under-inclusive at the very same time, and is hard to argue with that argument.
It's hard to argue with someone making perfect sense.
Now, nearly half of the 155-page preliminary injunction consists of the communications and actions that took place between the government and these various social media companies, and I just want to highlight some of them that I found either especially troubling or especially informative or representative of a common pattern of abuse that repeats throughout the court's finding, including where social media companies would initially push back against a certain demand and they would later give in under rising pressure, as well as discussing here what I think are some of the most egregious examples of the government's actions unquestionably going well beyond voluntary recommendations and requests. So let's start with the communications from the White House. So the key player here is Rob Flaherty, who, as you can see, is the former deputy assistant to the president and his former director of digital strategy. Now, as I mentioned a bit earlier in the show, the first contact between the Biden administration and social media came a mere 3 days into the Biden administration, at which time Rob Flaherty would contact Twitter about a parody account linked to Finnegan Biden, Hunter Biden's daughter, and President Biden's granddaughter. Now, I want to be clear here that all parties were completely aware of the fact that what we were talking about here was a parody account and that this account made that very obvious right from his own page. And yet, despite this, we would have Flaherty reaching out to Twitter saying, please remove this account immediately. And 3 hours after that demand was made, Flaherty would again call to Twitter and press them again by saying that he, in this case, speaks for the president, who, quote, cannot stress the degree to which this needs to be resolved immediately, end quote. And Twitter suspended the parody account within 45 minutes of Flaherty's second request. Now, next, on February 7th of 2021, Twitter sent Flaherty its, quote, Twitter's partner support panel, end quote, for expedited review of flagging content for censorship. Twitter recommended that Flaherty designate a list of authorized White House staff to enroll in Twitter's support partner portal and explain that when authorized reporters submit a ticket using this portal, those requests would be prioritized automatically, and Twitter also stated that it had been, quote, recently bombarded, end quote, with censorship requests from the White House and would prefer to have a more streamlined process. In fact, Twitter noted that in a given day last week, for example, every day we would have more than 4 different people within the White House reaching out for issues. And 2 days later, on February 9th of 2021, Flaherty would follow up with Facebook in regard to its COVID-19 policy. Now, he would actually accuse Facebook of calling what he called, quote, political violence, end quote, spurred by Facebook groups that were failing to censor false COVID-19 claims. Facebook responded the same day and stated that vaccine skeptical content does not violate Facebook's policies. However, Facebook stated that it will have the content distribution reduced and strong warning labels added, so in their words, fewer people will see the post. In other words, even though vaccine skeptical content did not violate Facebook's policy, they still treated it as though it did. Now, Facebook also informed Flaherty that it was working to censor content that does not violate Facebook's policy in other ways by, quote, preventing posts discouraging vaccines from going viral on our platform, end quote. Now, on March 15th of 2021, Flaherty insisted that Facebook get more aggressive about censoring what Facebook called borderline content.
You know what I think the problem is? Facebook.
Facebook? How so?
Well, look, we all know there's a lot of mixing of truth and fiction that's been on Facebook lately, and children lack the cognitive ability to determine what's true and what isn't on Facebook. That's why we now have young kids dressing up in costumes, eating poop, and having sex with antelopes in our town.
Now, this was content that did not violate any of Facebook's community guidelines, which contained no actionable misinformation. And Flaherty would also discuss Facebook, talking about them being, quote, the top driver of vaccine hesitancy, end quote. And in response to Flaherty's email, Facebook would respond with the following. They say, we obviously have work to do to gain your trust. We are also working to get you useful information on the level. That's my job, and I take it seriously. I'll continue to do it to the best of my abilities, and I expect you to hold me accountable. Now, Andy Slavitt, who was Biden's director of COVID-19 response, who was copied on Facebook's emails in this conversation, would add more pressure to this discussion by stating, internally, we have been considering our options on what to do about it. Now, to me, this could only mean that if Facebook wasn't willing to ban borderline content that the Biden administration flagged, that the Biden administration was considering how to use the police power to force the content off their site. Now, on Sunday, March 21st of 2021, noting that the White House had demanded a consistent point of contact with Facebook, additional access to Facebook, and their levers for tackling vaccine hesitancy content, this was followed by an extensive exchange of further communications throughout the day, and the final communication from Flaherty in that exchange would say, quote, I care mostly about what actions and changes you are making to ensure you're not making our country's vaccine hesitancy problem worse, end quote. And he would accuse Facebook of being responsible for the Capitol riot on January 6th of 2021 and indicating that Facebook would be similarly responsible for COVID-related deaths if it did not censor more information. Now, taken collectively, the court's finding was that the White House wanted to establish a formal arrangement with someone who could be contacted at Facebook who would have the authority to immediately pull down any specific post flagged by the White House for removal. Now, on April 13th of 2021, a Facebook report would note that vaccine hesitancy content does not violate Facebook's content moderation policies, but indicated that Facebook would still censor this content. and that this includes what Facebook called, quote, true but shocking claims or personal anecdotes, end quote. It also include discussing the choice to vaccinate in terms of either personal or civil liberties and concerns related to mistrust in institutions or individuals. And on April 14th of 2021, Flaherty would demand the censorship of Fox News host Tomi Lahren because the top post about vaccines that day was Tomi Lahren stating that she herself won't be taking a vaccine. Now, I get why the Biden administration would go after someone expressing such a selfish decision. The fact that really the only people here who would refuse to take the vaccine were all entirely Republicans tells you that this is a politicized issue, and perhaps that Biden has a point, at least on this one particular complaint, that publicly questioning the vaccine is totally unacceptable.
If the Trump administration approves a vaccine before or after the election, should Americans take it, and would you take it?
If Donald Trump tells us that we should take it, I'm not taking it.
And really, after all, what kind of reasonable, rational, progressive-minded, pro-science American would actually have the audacity to claim for themselves the right to their own personal opinion and decision in such matters based on a belief in a right to bodily autonomy and the right of conscience in personal health care decisions? Now, on April 14th of 2021, Andy Slavitt would go on to email Facebook executive Nick Clegg with a message expressing displeasure with Facebook's failure to censor Tucker Carlson. Slavitt stated, quote, "Not for nothing, but the last time we did this dance, it ended in an insurrection," end quote. Facebook reported the Tucker Carlson content had not violated Facebook's policy, but Facebook gave the video a 50% demotion for 7 days and stated that it would continue to demote this video. Now, on May 1st of 2021, then White House Press Secretary Jen Psaki would publicly begin pushing Facebook and other social media platforms to censor COVID-19 misinformation. Now, at a White House press conference, Psaki publicly reminded Facebook and other social media platforms of the threat of legal consequences if they do not censor misinformation more aggressively. And Psaki would link the threat of a robust antitrust program with the White House demands for more censorship.
President's view is that the major platforms have a responsibility related to the health and safety of all Americans to stop amplifying untrustworthy content, disinformation and misinformation, especially related to COVID-19, vaccinations, and elections. And we've seen that over the past several months, broadly speaking. I'm not placing any blame on any individual or group. We've seen it from a number of sources. He also supports better privacy protections and a robust antitrust program. So his view is that there's more that needs to be done to ensure that this type of misinformation, disinformation, damaging, sometimes life-threatening information is not going out to the American public.
You're saying more that needs to be done. Are there any concerns, though, about First Amendment rights? And where does the White House draw the line on that?
Well, look, I think we are, of course, a believer in First Amendment rights. I think what the decisions are that the social media platforms need to make is how they address the disinformation, misinformation, especially related to life-threatening issues like COVID-19 and vaccinations that are continue to proliferate on their platforms.
I want to ask you.
Now, it should be noted that Mark Zuckerberg had previously said that the kind of antitrust program that they are being threatened with here would pose, as he calls it, an, quote, existential crisis, end quote, to the continued existence of Facebook. Now, this to me is truly one of the most disturbing of all threats, and it beggars belief that the White House press secretary could say that, basically that if a social media company doesn't comply with unconstitutional demands by the government to censor viewpoint-based speech, that they would be taking legal action by blatantly abusing antitrust laws and bringing an antitrust suit not to, regulate the company for engaging in anti-competitive conduct, which is what antitrust is supposed to even be about, but as a punitive measure to punish this company for not censoring citizens based on viewpoint discrimination when they knew, because Mark Zuckerberg had previously stated this, that the legal consequences that she was threatening them with would literally destroy their company and their ability to exist. And the major news networks whose journalists were in that room and heard her say that are the very same networks who are now running stories claiming that this is a case that seeks to prevent the Democratic administration from simply asking media companies to voluntarily remove content. And on July 20th of 2021, a White House press conference, White House Communications Director Kate Bedingford would state that the White House would be announcing whether social media platforms are legally liable for misinformation spread on their platform and examining how misinformation fits into the liability protection granted by Section 230, and they were considering whether 230 should be amended or repealed for the sake of holding these companies accountable in a real way.
Kate, definitely calling the shots and calling it out is important, but as a candidate, the president said he was open to getting rid of Section 230, and I'm just wondering if he's open to amending 230 when Facebook and Twitter and other social media outlets spread false information that cause Americans harm. Shouldn't they be held accountable in a real way? Shouldn't they be liable for publishing that information and then open to lawsuits?
Well, we're reviewing that, and certainly they should be held accountable. And I think you've heard the president speak very aggressively about this. He understands this is an important piece of the ecosystem.
And on November 30th of 2021, the White House's Christian Tom emailed Twitter requesting that Twitter watch a video of First Lady Jill Biden that had been edited to make it sound as if the First Lady were profanely heckling children while reading to them. Twitter responded within 6 minutes, agreeing to escalate with the team for further review. Twitter advised users that the media had been edited for comedic effect, and Tom would then request Twitter apply a, quote, manipulated media, end quote, disclaimer to the video. After Twitter told Tom the video was not subject to labeling under its policy, Tom disputed Twitter's interpretation of their own policy and added Michael LaRosa, the First Lady's press secretary, into the conversation. And further efforts by Tom and LaRosa to censor the video on December's 9th, 13th, and 17th would finally result in the video being removed. Now, at an April 25th, 2022 White House press conference, after being asked to respond to news that Elon Musk may be buying Twitter, Jen Psaki would again mention the threat to social media companies to amend or repeal Section 230, linking these threats to social media platforms' failure to censor misinformation and disinformation. And in addition to misinformation regarding COVID-19, the White House also asked social media companies to censor misinformation regarding climate change, gender discussions, abortion, and economic policy. On June 14th of 2022, the White House National Climate Advisor Gina McCarthy would blame social media companies for allowing misinformation and disinformation about climate change to spread, and explicitly tied these censorship demands with threats of adverse legislation regarding the Communications Decency Act. 2 days later, on June 16, 2022, a memorandum discussed the creation of a task force to reel in what they called online harassment and abuse, and to develop a program for targeting disinformation campaigns. Now, this despite the fact that they were actually targeting something that was facially unrelated to a disinformation campaign. The court's findings were that they labeled these efforts to remove disinformation because they had no authority to target the type of content they were actually going after. And the memorandum also calls for the task force to confer with technology experts and again threaten social media platforms with adverse legal consequences if the platform did not censor aggressively enough. And on August 11th of 2022, Rob Flaherty would email Twitter to dispute a note added by Twitter to one of President Biden's tweets talking about gas prices. Now, on page 61, there was also a finding made against the FBI that at the FBI's behest, the FBI communicated with social media platforms using two alternative encrypted channels known as Signal and Teleporter. The court found that one reason that this had been done was so the FBI could routinely take advantage of a feature these encrypted channels have, which is namely self-deleting messages. This means that in clear violation of federal laws under 28 U.S.C. Section 1732 and 44 U.S.C. Section 3106, as well as Title 36 of the Code of Federal Regulations, Part 1230, which is punishable under 18 U.S.C. Section 641 and Section 2071. These various laws and regulations pertain to the FBI engaging in unlawful removal, defacing, alteration, corruption, deletion, erasure, or other destruction of records whenever they would routinely communicate with these social media companies using technology that irrevocably deleted their communications. Now, when it came to the White House's defense of these and the other plethora of actions, they cited in this preliminary injunction a couple of defenses of their actions that really stood out to me. The first was that the court found that in defending their actions, the Biden administration, quote, while not admitting any fault in the while not while not admitting any fault in the suppression of free speech, defendants blamed the Russians, COVID-19, and capitalism for any suppression of free speech by social media companies. Sorry, let me try and read that again with a straight face. While not admitting any fault in the suppression of free speech, while not admitting any fault in the suppression of free speech, the defendants blamed the Russians, COVID-19, and capitalism for any suppression of free speech by social media companies.
Why don't you try speaking in words instead of your damn dirty lies?
Now, another important part of the court's opinion comes from, or comes in the form of the Biden administration's defense of a statement, and we talked about this statement briefly a moment ago, but a statement that was made by White House Communications Director Kate Bedingfield in her announcement that the White House is assessing whether social media platforms are legally liable for misinformation spread on their platforms and examining how misinformation fits into the liability protection process of Section 230 of the Communications Decency Act. Now, rather incredibly, the defense that was offered by the Biden administration about why those Section 230 threats cannot be seen as coercive was, according to them, because it wasn't just them, and that many, in fact, Republicans wanted to repeal Section 230 as well. Now, the court immediately and rightly flipped that on its head because it noted the fact that there was bipartisan support to revoke Section 230 actually only made this threat more real. So, turning to the text of the opinion of the court, this is the response that they gave to that defense. With respect to 47 U.S.C. Section 230, defendants argued that there can be no coercion for threatening to revoke and/or amend Section 230 because the call to amend it has been bipartisan. However, defendants combined their threats to amend Section 230 with the power to do so by holding a majority in both the House of Representatives and the Senate, and in holding the presidency. They also combined their threats to amend Section 230 with emails, meetings, press conferences, and intense pressure by the White House, as well as Surgeon General defendants. And regardless, the fact that the threats to amend Section 230 were bipartisan make it even more likely that the defendants had the power to make this amending to Section 230. They go on to note that all that is required is that the government's words or actions could reasonably be interpreted as an implied threat. And with the Supreme Court recently making it clear that Section 230 does shield social media platforms from legal responsibility for what their users post, according to Gonzalez v. Google, Section 230 is even more valuable to these social media platforms. These actions could reasonably be interpreted as an implied threat by the defendants amounting to coercion. Now, I want to wrap up this video here with a few of my own personal thoughts on these issues. First of all, it should make everyone's blood run cold to hear the government ever claim that they are the arbiter of truth. No one can deny that during the pandemic there was a vast amount of mis, dis, and malinformation that proliferated. Now, much of this information was harmful. And one of the most prevalent sources of this information was the federal government. Much of the information the government would suppress and censor has come to be widely accepted fact. The lab leak theory, the limited effectiveness of mRNA vaccines, the health risks of the vaccine, the effectiveness of natural immunity. These are all claims that were categorically denied by the government as not only false but downright paranoid conspiracy theories, and that anyone who made these claims was subject to censorship and social ostracization. Yet, these are all claims that are now recognized as at least likely true statements, if not categorically proven facts. We shouldn't have to have such overwhelming and shocking evidence about the fallibility, if not the intentional deception by government actors, to understand that making other people who happen to get their job through the democratic process the infallible deciders of what is true and what is false is a horrible idea. Now, if in situations like the pandemic that happened, if the government wants to act as a source of true and factual information, that's perfectly all right. But letting them claim that they are the only source of what is true and factual is unbelievably ignorant and dangerous, and even so in lesser circumstances where the consequences were nearly as severe as they were with the recent pandemic. Besides, no one who supports the current government, and I want to stress I don't just mean the current government right now, but the current government at any given moment in time, they never consider that there will be a time when it won't be their guy deciding what is true and what is false. And so I ask to all of the news organizations and political commenters and Democratic voters who are defending the Biden administration and the actions they took in this case because you trust Joe Biden to only abuse his power in ways that will help you and harm Republicans. Consider the very real possibility that come January of 2025, you may very well be handing this power to jawbone social media companies right back to Donald Trump for another 4 years. are you really okay with that? Because at the moment, the guy who is abusing this power is doing so in a way you approve of. Look, come on, people. No one with a shred of moral fiber should be defending a single thing in this case. The government is violating your First Amendment rights, and the fact is there is no First Amendment exception for a viewpoint just because it might be wrong. And that is even truer when you are talking about a viewpoint that you merely assume to be wrong because it is a viewpoint that disagrees with yours. Well, that is really all I have for you guys here today. Thank you so much for tuning into Legalese. I will be back very soon with my second video on Murthy v. Missouri. In the meantime, if you would please do all of those things for me that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked the video, hit the like button. If you disliked it, hit the dislike button. I would greatly prefer you hit the like button, but I'm not going to tell you what to do here. Don't forget to subscribe to the channel so you always get notifications whenever the next episode of Legalese is put out. Please take a moment and, first of all, leave me a comment. Let me know what you thought about the show. And second of all, take a moment and share this show. Just share it out to your social media, or just share it with one person who you can think of right now who you think would find this information helpful or useful or interesting. And if you would do that for me, I would greatly appreciate it. And until next time, this has been Bob for Legalese, talking about Murthy v. Missouri, and of course, as always, Carthago delenda est.
Motherfucker, like Freddie Mercury. Motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full